Good morning, everyone. Welcome to the Flexible Working webinar. I'm sure we'll have other people joining throughout, but we do have a lot to get through. So I will crack on and start now. So the purpose of today's webinar is to consider the statutory right to flexible working, as well as any informal requests that can possibly be made, statutory protection that employees have. Flexible working, as you know, is very wide, and I'm going to start with the definition. So the definition is any working arrangement that meets the needs of both the employer and employee regarding when, where, and how an employee works. So you can see from that it is a very wide description of flexible working, and as such puts a burden on you as employers to comply with any statutory requirements and deal with things correctly. So today we're going to hopefully understand the legal landscape and the changes that have taken effect. I've tried to make this as practical as possible with any examples where we can, so that you can actually go away from here and appreciate how to apply the law rather than me just spouting the law at you. So we're going to look at how you manage the requests. We're also going to look at mitigating risks, which clearly is high priority for everybody. Then I'm going to look at how you need to do your policy updates and practicalities. I'm also going to try and give you some examples of refusals, because that seems to be a lot of the questions we have from clients. Is flexible working request has come in regarding ABC. How can we refuse under the new regime? So we'll see if we can get some examples in as well. So let's look at the background and the legal landscape. So flexible working was initially introduced in 2003, and it was quite a prescriptive introduction, and it was very limited. The pre-2014, if we can say so, from 2003 till 2014, the request was to care for certain children and adults. So as you can appreciate, it was a limited request. Sorry, I'm just getting rid of my screen. The employer and employee were required to follow a prescriptive statutory procedure, which I'm sure you're all aware of. Any request could only be refused from one of the 8 prescriptive reasons given in the legislation, and employees could only make one request in a 12-month period. So it was quite easy to deal with flexible working requests at that point, because it was either you follow this, you do this, we can accommodate it for this, and therefore it's accepted. From the 30th of June 2014 to the 5th of April 2024, changes came in where employees were required to have 26 weeks continuous service in order to make the request. Can make a request for any reason under the statutory scheme. So there was a real shift change, wasn't there, from where it was focused on children and adults to anybody. It had to be by way of a written request. There was a 3-month timescale to deal with the request. Any request could only be refused, again, for one or more of the 8 reasons set out in the legislation. Only one request in a 12-month period. Again, the major change there was that anyone could claim and apply, for flexible working. So as of April 2024, changes were introduced by the Flexible Working Amendment Regulations, which came into force on the 6th of April. Now, I'm hoping that this will help as a sort of aid memoir, if you like. So we have the previous legislation and the new legislation. So it sets out in, well, simplistic form. I like simple if we can do it. So it sets out in simplistic form the differences and, more importantly, the new legislation and what you need to be following. So you can take that away and review it. Just as an aside, I think the slides will be sent out. It is being recorded, so don't panic if you can't get everything down. So let's focus now on how we deal. I mean, we can go on about how we used to deal with it, but that's not what you're here to know. Let's look at the process now, come April last year, but moving forward, this is key to how you deal with them. So the eligibility can only be made by an employee. So contractors, self-employed, agency workers, etc., not included. The change is that an individual can make 2 requests in 12 months. There is a lot of narrative around when the time starts for another application to be made, but simplistically, I would say that as soon as you give the decision on the first application and there's a change in the terms and conditions, that's where your time limit runs. So from there, they have another 12 months in which to make another application. So the types of changes are set out in section 80F1 of the ERA, and there are a huge amount of work patterns that it covers. So the 3 changes that are specified are hours, times, and place of work. Underlying these 3 categories, there are a wide range of work patterns to consider. So it goes into some detail on, changing to an annualized contract, job share, part-time, full-time. It's all the things that you deal with on a regular basis that are included within the legislation. It provides very few limits as to what the employee can request by way of a change to their working pattern. So it's almost a free-for-all for the employee to claim. There is no prohibition to agreeing a temporary change, but this should always have an agreed timescale. So again, and I suppose this ties in with any informal applications. So if there is a temporary change, I can't stress enough how important it is to put an end date on it. Not the trial period we're talking about. This is for a period of 6 months, because after 6 months, my working pattern can change back, my child goes to nursery, etc. Have a date on that. The employee's request must be in writing. It has to be dated, and it has to specify the change and the date they wish the change to take effect, whether any previous request has been made and when, and state that the request is made under the statutory procedure, not an informal request. What you'll notice there is the omission of the fact that the employee previously had to say how it would affect the business and ways in which they believe it can be accommodated. They no longer have to do that. And that was quite useful for employers, because it allowed us to put some of the burden on the employee to make the request. So how do you manage the process? And this is absolutely key, as you'll see later when we talk about mitigating any potential risks. You must deal with the request in a reasonable manner. The reason I've put that in inverted commas is that it's quoted in the regs at section 80G that you must deal with it in a reasonable manner, but helpfully, there's no statutory definition of what amounts to a reasonable manner. I've put at the bottom there, the ACAS code states that it should include carefully assessing the effect of the requested change for both employer and employee, such as the potential benefits or other impacts of accepting or rejecting it. Personally, don't think that's very helpful either, but we'll go on to reasonableness shortly. But what we see as a reasonable manner will be dealing with the request in a reasonable timescale, etc. A key change is bullet point 2. If you're going to refuse any request from the employee, you have to consult with them before refusing. So if you're happy to accept the request, that's fine. You can just write to the employee and accept it. If part of the request or all of the request is going to be refused or amended alternatives, you have to carry out a consultation with the employee. You need to notify the employee of its decision within 2 months. Now, this 2-month timescale can be extended by agreement if there are concerns that, for instance, at the moment, we've got annual leave and it's impossible in some cases to deal with things. But it has to be mutually agreed for any decision, any 2-month period to be extended. The 2-month period includes any appeal. So it's not 2 months just to deal with the application itself and the request. It's 2 months to get the whole thing done. So that's quite difficult in some cases, but you just need to be mindful that once you give the decision, the appeal also has to be done within that time. This is where we get a lot of questions. You know, we cannot sustain this flexible working request because of ABC. So the grounds on which you can refuse are for prescribed reasons set out in the legislation. So Section 80G1B says when selecting the grounds for refusal, the test is a subjective one on the part of the employer, which is quite helpful because it means that if the employer believes one of the grounds applies, the test is satisfied. There is no test of reasonableness of the decision at present. However, what I would say is that is being considered as part of additional reforms, that reasonableness should be part of a refusal request, but at the moment it isn't. So we have the reasons that we can refuse. So I've tried to put together some examples here, and I'll go through the reasons firstly. So we have the burden of additional costs. So that could be quite an easy one to hang your hat on, if you like, for want of a better word. So say we have 2 managers apply for a post together as a job share. Both have the skills and experience needed, but want to balance work-life. So they want to have a nice work-life balance. In line with the organisation's policy of considering flexible working, the employer seriously considers their request. Both managers want to work 3 days a week. Employers happy to appoint, but he's unable to afford the increased payroll costs. The employer discusses alternative working patterns around 2.5 days each with them, but they are not prepared to change their pattern. In light of this inability to compromise, they turn down the request for flexible working. Is that appropriate? Well, we've done the consultation with them. We've considered their request seriously. We can't accommodate on the grounds that they request, but have put forward alternatives. So on that basis, it would tick the box of refusal on the grounds of a burden of additional costs. So the second is a detrimental effect on ability to meet customers' demands. This is sometimes quite a general area, and it is something that a lot of clients do reasonably have as a justification. So if we have an example of, I've been quite keen on a small estate agency receives a request from someone to work compressed hours. Again, go back to the definition and the areas of flexible working. So compressed hours would fall within that category. Working 4 days longer and freeing up Thursdays, for instance, which would allow him to do part-time study. So we basically wants to work 4 longer days. The employer is concerned that the employee will not be able to deal with time-dependent issues. So it's an estate agency, he's not working 1 day, he's working longer outside office hours. Is there a need for him to do that on a regular basis? The estate agency employer feels it may lose sales and get complaints, and they refuse that request on grounds of detrimental effect on customers' needs. So if we were in that position, we would need to look at whether the impact would be substantial and whether we could sustain it by putting someone else on his case for the Thursdays, etc. But on that basis, it may be the appropriate way forward would be to consider a trial period. Do it for a specified period of time, putting that in writing, based on we will agree to you working these hours for a period of 3 months, subject to no client complaints, ability to perform and continue with your sales, etc. So you're not refusing the request, but you're being reasonable in allowing an alternative. If he was to, or if he were to ask for 3 days off, it wouldn't be sustainable. So I think you could definitely refuse on the detrimental effect. Similarly, 2 days, that may be one where you monitor how it would proceed. Inability to reorganize work amongst staff. I mean, this is a difficult one, isn't it? Because you then have the staff morale who are having the work organised amongst them to consider, as well as the person putting in the flexible working request. If the person has particular skill set that other members of that team don't, then I would say, well, you can't reorganise it amongst them because that's the skill set we require. As long as you consult on that one, I believe that if you have a small team, then the reorganisation and redistribution of work amongst staff is going to be more difficult, and therefore, following consultation, the working request may be refused. Similarly, inability to recruit additional staff. this is where somebody, and again, you probably see this quite frequently, where somebody asks to work from 10 till 3. And that's difficult in itself if you operate 9 to 5. You are going to struggle to get somebody in place from 9 till 10 and from 3 till 5. That would be a reason for refusal of request. If somebody asks to work from 9 till 4 and there's only an hour, it wouldn't be a reasonable reason to refuse. So as you can see, it is all subjective, and it's all based on how you operate. If you have, sorry, just saw a question come in. If you have a business where, if you have a larger business, you're more able to accept the requests on the basis that you would be able to sustain the impact of a flexible working. Smaller businesses, it can't, you're going to struggle more. Detrimental impact on quality and performance. I mean, it's not something that is, it's not rocket science, is it? If you have somebody who works on, if you have somebody who works in let's say a garage, and wants to work part-time in the garage, but at the moment we've not long set up, this person is extremely experienced and other people in the garage have only just started, apprentice mechanics, let's say. So apprentice mechanics, the individual wants flexible working. Our concern is both quality and performance related, because if we were to allow the flexible working request, there would be a lack of supervision on the apprentices, and there would be a concern for the quality of the goods, car, processes, etc. So on that basis, we could refuse the request, but we could caveat it. At the moment, we can't accept your request. She can make 2, or they can make 2 within the 12 months. Can't accept it at the moment because it would have a detrimental impact on the quality of the goods we supply. Insufficiency of work during the period the employee proposes to work. Now, this is, again, a common theme that we have. Somebody wants to do flexible working, wants to start at 8 o'clock and finish at 3. Office hours are 9 till 5. It's a customer-facing role. They need to be available on the telephone from the point of from the point when the business opens, 9 o'clock. If we were to accept the request, they would be sitting there doing nothing, potentially, because they're a customer service person, from 8 till 9, and then we would have no one in situ from 4 till 5. So on that basis, it would not be reasonable for the request to be accepted, and we would then look at alternatives. Would it be 8:30 till 4:30? Can we cope with half an hour? Can they do admin in that half an hour? So all these points just need to be seriously considered and evidenced if possible. And as I've said there, it must provide concrete evidence of any refusal. So transparency is helpful. The more you give to the employee to confirm why you're refusing, the safer your grounds are, for want of a better word. There are other examples, and what I'll do is I will put these I'll add a few more examples onto the slides at the end, so that when you receive your slides, it will have these examples included, if they've been any use. Okay, so rejecting a request and proposing an alternative. So we need to be conscious that even accepting part of a request and rejecting another part and proposing an alternative is not accepting the employee's request. So you have to consult with them. You as employers may propose alternative working. So you can do this on the basis that we've agreed there is an alternative working pattern, but it's subject to a trial period. You've consulted on that and it's been agreed. And when consensus has not been agreed during consultation, you can propose an alternative, but again, that's going to be subject to a trial period. Don't confuse the trial period with a redundancy trial period. This is not a statutory trial period at all. It's not set out in the legislation. However, it's not prevented in the legislation either. So ACAS has suggested that where an employee request cannot be accepted in full, the employer and employee should discuss any alternatives to modifications to the request. So much as we said in the examples, you can sit down and consult. It's a consultation. And I always say when it's a consultation, it's a two-way street consultation. Put forward options. You know, if they don't accept them, then at least you've tried, and your rejection will be seen as more reasonable, although we don't have a definition of that, but will be seen as more reasonable should there be a claim. Okay, so the legislation does not expressly provide for an appeal process. Again, it's very strange, but you will inevitably allow the employee the opportunity to appeal. ACAS Code of Practice suggests that allowing an appeal is good practice and, here's that word again, reasonable. You need to go to some lengths to ensure that the process in any decision is reasonable, but that's not to say that the employee doesn't have to do anything. My bugbear with appeals is that the employee says, I want to appeal the decision, full stop, thank you. Well, that's not really a valid appeal. A valid appeal is only such, and this applies for disciplinary grievance, this applies across the board. An appeal is only an appeal, in inverted commas, if written reasons are specified. There has to be I am appealing because of ABC. So they need to include additional information they wish to be considered. And if there are any, specify the procedural flaws. So if an employee does not do that and doesn't comply with that, you go back to them and say, this isn't a valid appeal. Please set out your grounds. Otherwise, you don't know what you're dealing with. You must hold the meeting without unreasonable delay and give both parties a reasonable time to prepare. I would focus on your disciplinary and grievance policy for that. The timescales that you generally have within your policies, I would duplicate them to apply here. So 48 hours, if you like, 48 hours notice, right to be accompanied. You'll see at the bottom, I've put the appeal needs to be carried out within the 2 months, unless, of course, you've mutually agreed otherwise. Accepting a request. I have no idea why I put the dog on this, but it came first. So, accepting a request. As you will all know, if a request is accepted, it constitutes a contractual variation to the employee's contract of employment. It will be a permanent change unless otherwise mutually agreed. So again, it goes back to, if you have a timescale on it, make sure it's in writing. Employers must issue a Section 4 statement. That is a written statement of the employee's terms and conditions in accordance with Section 1 of the ERA. Must be given within a month of the change taking effect. It doesn't mean you have to do a brand new contract, but you can if you want. So if other things are changing as well, or you want to update it, at that point, yes, do another contract. But alternatively, don't make extra work for yourselves. You can do a letter, a compliant letter, expressly setting out the terms and get the employee to sign it. So it's almost an addendum, isn't it, that you're going to then keep on the employee's file. I would always suggest that you review the arrangement after a reasonable period. So keep that dialogue going, make sure it's working for everyone. And again, that just mitigates any potential risk moving forward. Like that talk. Okay. COVID-19 changed the whole landscape, didn't it? So it made us all work at home, which was great because it was really sunny, I seem to remember. So that was fine. But following COVID, there's been a complete shift change, as you know, with working from home and hybrid. It's a given now, isn't it? In the majority of cases, if you're looking at recruitment, 9 out of 10 will want to work hybrid or remote. 90% of employees wish to continue the arrangement post-pandemic. So a home worker exclusively based at home, hybrid, work, base and home. What I would suggest, if you have these requests, which you will, is consider the contractual obligations and tailor them to the requirements. So much like you would do if you were accepting a flexible working request, do that Section 1 statement of terms. So do an addendum letter to the contract advising of the change in the T's and C's and the contractual obligations. Make sure you have policies and procedures in place to set out the arrangements and conditions. Also have a caveat, although you are hybrid and although you work from home, there may be occasions when you are required to attend the office for meetings, etc. Make sure you have that as part of your policy and procedure. One significant issue is confidential information and personal data. You can't have employees sitting at the dining room table with, confidential information sprawled all over when their mates come round for a glass of wine. So make sure that you have procedures in place. So locked cabinets, a separate office. These are things, particularly if you work in a sector where data protection is key. The last thing you want is an ICO or a data protection leak being made because processes haven't been followed. Consider the health and safety arrangements, including risk assessments. Make sure that their office is safe, they've got the equipment that they need, etc. And how to manage the work and to supervise remote working. It's not as easy, clearly, as managing and supervising everyone when we're all sat in the office, but look at your teams. Well, I'm teaching grandma how to suck eggs here, but yeah, consider the pros and cons of any application, and apply a consistent approach. You can't give one person hybrid and another person not, just because you don't want to give two people hybrid. If they're of the same level experience-wise, if they've been engaged by you for the same period of time, it would be considered unreasonable. But don't forget, it's not a statutory request at this point. Okay, so how do we mitigate a risk of a claim if we refuse a request? Because obviously you're not going to get a claim if you agree in the request. So make sure you deal with the request in accordance with the legislation. So it's a statutory request. You have to consider the prescribed reasons and follow it to a T, basically. So if the request cannot be accepted in full, I'm repeating myself, but it really is important, there must be consultation before you reject it. Organise a meeting to consult with the employees in a timely manner. I've said 48 hours because that's usually what everyone has in their policies. Allow them the right to be accompanied. It's the usual statutory right, so it'd be work colleague or trade union rep. However, I would caveat this with, if you believe there is an issue with the employee, if there is a disability issue, etc., consider whether you would allow them to be accompanied by someone else, a partner, not necessarily legal rep, I wouldn't say, but, you know, can you allow a partner to come, a friend? Consultation meeting should allow for a full discussion and consideration of the request, which means minute it. Make sure it's minuted and that you've covered everything that the employee has put in their request. The decision needs to be communicated in writing and without delay. The decision, unless you've changed your mind and the decision is going to be accepted in full, that decision will not be able to be made and given at the meeting, because the inference would be that it was potentially a predetermined. So go away and think about it. Provide full reasons for the decision and any evidence or information you've relied on. So go back to the prescribed reasons for rejection, pick the one you're relying on and almost bolster it with the evidence that you've obtained. So if you've had a look to see if you can recruit somebody between then and then, and you've been on Indeed and there's nobody there, show it to the employee. So do some digging. Allow the appeal process. Make sure you advise on the outcome of the appeal process, and do it all within 2 months. Not a long time, 2 months really, but moving on to minimising the risks, there's no statutory requirement for a sufficient explanation. So if we go back, you'll see there that it says decision needs to be communicated, full reasons for the decision, but there's no statutory requirement of what amounts to a sufficient explanation. So again, ACAS have said that you need to set out the steps taken to investigate whether the request can be accepted. Much like we said in the other slide, just put your evidence out there. You know, you've obviously looked at it in order for the request to be refused, so just give that to the employee. Also, any practical aspects of the job that prevented rejecting the request, any alternative options considered, any data used to make the decision, much like we've just said. So, you know, we can't recruit between these hours. We don't have the budget to allow for this job share provision. So make sure that you just tick all the boxes. So whatever grounds you're refusing on, minimise the risk by these 5 points. Policies. It's a simple one really, isn't it? Have a clear policy and procedure for all requests to be made. Your handbook is there to advise the employee on the company processes and procedures. So in order for the employee to follow the process and to know what the expectation is, they need to have a clear and concise policy. I would base your policy on the statutory framework, which is a few slides before, include specifically how to make the request, what the employee should be included in the request, the right to be accompanied, the appeal procedure, and time limits. So just make sure your policy provides all that information that they require. I don't think we need to go into too much detail as to the grounds we can refuse on, because your employee handbook is there to give the employee information. So we could put it in on the basis of the employee would reserve the right to refuse should any of the following prescribed reasons arise. So, but don't go into any further detail on that. So what can they do? What can employees do? And what complaints can they bring? This is quite an interesting look at flexible working, to be honest, and whether the legislation is such that it does have any teeth. And I question whether it does. So let's look at the complaints that can be made. One is that the employer failed to deal with the request in a reasonable manner. Now, you will be dealing with it in a reasonable manner because we've set out on the previous slides what you need to do. So you will tick all those procedural boxes. You will carry out a meeting within a reasonable timescale. Another complaint that they can make to a tribunal is the request was refused without consultation. That's absolutely key. It's much like the old, we used to have a meeting. Make sure it is a constructive meeting, so it's consulting. That's going to be one of the key areas where tribunals may take a hefty hand, to be honest, because it's a fundamental procedural flaw. The employer failed to notify the decision within the prescribed period of 2 months. The request was rejected for a reason other than one of the statutory grounds. Don't forget, you can only reject on one of the prescribed reasons, which you've got a list of that you can run through. The decision to reject the request was based on incorrect facts. I would hope that wouldn't be a regular occurrence because you'll have carried out the appeal, which would have identified any incorrect facts on which a decision was based. So the remedies, this is an interesting point. Well, it's interesting if you find these things interesting. The tribunal cannot question the commercial rationale or business reasons behind the decision to refuse the request. So much like when you talk about redundancy, they don't reinstate, they don't put their decision on whether you made the right or wrong decision on redundancy. Same here. So if you believe that you can refuse the request, the tribunal will not substitute its own decision on whether the request should have been granted or not. So the tribunal is there just to look at the complaints as above. It's not there to make a decision on whether a flexible working request should have been granted, and it wasn't. So I just said about the tribunal's teeth. It is restricted to the extent it can scrutinise any decision that you've made. So as long as you go back to the other slides and look at how we make sure we have mitigated the risk and how we've processed the application, the tribunal cannot reinstate your decision. So it can't change your decision. It can only look at the process. So the role is restricted to reviewing the procedure that was followed. So again, tick your boxes on that process. Consider whether the request was taken seriously. That's your consultation. If you have a meaningful consultation, then you are taking the request seriously. And again, you will have some of the examples at the end of here that will show and identify what you need to do to take it seriously. Was the decision based on the correct facts? Again, hopefully your appeal process would have done that. And whether the reasons given fall within the permitted grounds. So those are, you know, it's quite narrow, really, what they can do. You know, they can't, the key is they can't substitute your decision for another one. Where a tribunal finds a claim is well-founded, it must make a declaration and make either or both of an order for reconsideration of the request or a compensatory award of up to a maximum of 8 weeks' pay. The tribunal will consider what is just and equitable in relation to the compensatory award and reconsideration of the request. So you're going back to square one, really. At this point, the employee is still employed. So they've made a claim that you failed to consider seriously or procedurally correctly their flexible working request. So even that brings with it an award of up to 8 weeks' pay. Practicalities to reduce the risk. So you've got the 8 weeks' pay. If an employee considers, and this is a whole different webinar, if an employee considers that you have refused their request and it is based on the fact that, based on a protected characteristic, a discrimination claim will follow. Constructive unfair dismissal claim. The fact that they have made this claim, flexible working request for childcare reasons, automatically falls within the protected characteristics. So you need to be very careful that any potential discrimination issues are addressed. So at the back of your mind, when any flexible working request comes in, you need to consider whether the rejection of the request has put a particular group at a disadvantage, and can that be objectively justified? So as a result of the decision you've made, I am disadvantaged due to my childcare. It is basically treating me less favourably because of my childcare or because of my disability, etc. So I would say that is a key issue in relation to flexible working that is for another webinar, because once we've got all the basics in place, we then need to be looking at identifying areas of discrimination and how to deal with those requests, because it's going to be more difficult to refuse, and it's not going to just basically be on any of the prescribed reasons. In order to reduce your risk, I wouldn't say completely, because there's no such completely, because employees will have that right to make a claim no matter what you do. Make sure you meet the statutory requirements. Avoid technicality points. So I would avoid saying, well, you've put it in writing, but you haven't addressed it to the right person. You know, don't be difficult about it. They've put their request in writing. Don't forget, they don't have to tell you how it affects you as a business anymore. Consider alternatives rather than the request alone. Have that consultation, consider everything that you could possibly put on the table. Carefully consider bullet point 4. I've put this in because it seems to be something that we're going to have a culture change, and there will be a shift change towards flexible working. So you need to carefully consider whether a role cannot be performed flexibly, and whether your view on whether it cannot be performed flexibly is justified. It would not be sufficient for you to say, we don't like people working flexibly. We don't like people, having flexible hours because it's not the done thing and they need to be here all the time. Why? So you need to ensure that that is justified. You'll see there that I've put the discrimination issue. If there is if anyone feels that that is something they'd like to have in another webinar as a separate issue, please let us know, because we're always keen to do things that, to put webinars on that are of use to you. So please let us know if that's something that you would appreciate. Explain any decisions fully and clearly, be consistent, and I'm going to end with the one that I always harp on about, and that is maintain records. Minute meetings, maintain records, have that paper trail in place. And thank you for listening to me rabbit on for quite a while. If anyone has any questions, and I can see someone's come back saying, yes, they would like one on the discrimination elements, happy to do that. That will definitely fill an hour and more. Any questions for anyone? Oh, another. Oh, right, okay. Where's my Q&A? Right, let me go down to some of these questions. So, first, if I can go through the first one, not a silly question. If we have to provide concrete evidence for refusal, say the reason is for how does this evidence element work, or would we need the evidence saved on file just in case? So well, you don't have to show them financials, but it would be sufficient, wouldn't it, to say, well, let's use an example. Well, you're a job share, your salary is this, your salary is that. You want to have a day overlap between you. We can't afford that because that would be the cost. So no, you don't have to show financials, but you are giving an overview. So it would be some sort of evidential, this is how much it would increase by way of salary. I mean, if you want me to go into any more detail on that one, happy to. Next one. Should a change to hours or something like that always be submitted as formal, or would it be okay to have a chat? Informal is fine. It's not covered. So it's almost the home working hybrid, isn't it? It's the informal application. So yes, happy, that would be fine to be done as a one-to-one. It's triggered, the flexible working request is triggered by the employee putting it in writing. So if somebody says to the manager, can I have a chat, please? Is there any chance I can do ABC? That isn't triggered by the flexible working statutory provisions. So yes, have a chat on a one-to-one. Make sure you confirm the details in writing. Bear with me. Oh, yeah. how do we deal with a situation where you hire someone on a set basis, full-time working, office-based? Once hired, they make a request to work remotely and reduce their hours. You deal with it in accordance with the process we've just identified. I'm afraid it's day one right now, isn't it? If it's somebody that you've just hired, your argument could be performance quality, couldn't it? We don't know that you are, you know, we need to manage your performance. We need you in on site at the moment because you've only just been engaged. So as long as you can show that, unfortunately, they do have that right. But yes, it would be performance quality based. Sorry, I'm sorry these are brief. Whose obligation to provide equipment necessary to make the homework safe? Employer, I'm afraid, because you are vicariously responsible, aren't you? Unfortunately. Oh gosh, hang on, I'm just going down this more. How should we deal with a situation? Accepting crash could set a precedent. I know it's a nightmare. Do you know what? I had this today. Once we've accepted one person, how can we refuse the request for another person in a similar situation? Look at your prescribed reasons. Yeah, look at the prescribed reasons, because you would have to you would have to reorganize work within the department. Is that going to be feasible if you've got another person off? It's almost first come, first serve basis, isn't it? If you're going to, you can't, you know, if you can justify that another person working flexibly would not be possible because of one of the prescribed reasons, i.e. the workload, we can't recruit staff to do that job on one day a week, etc., then it doesn't set a precedent. So you can't say one person in the accounts department has put a flexible working request in, that's been accepted, another 5 people in accounts apply. We don't have to request them because we can go through our prescribed reasons and reject. No such thing at the moment as a precedent, in my opinion. If someone puts a request in and it's declined, is there a period they have to wait to submit the same request again? Well, they're only entitled to put 2 requests in within 12 months. So there's nothing that I've seen that specifically states, although I will have a look, what the timescale is. But if they can only do 2, they're going to have to, I would suggest, a 6-month timescale. I will have a look and see if there's anything specific, but I would say you can't make another one. Again, put it in your policy if I don't find a specific, but you know, you can't make one for another 6 months. Seems reasonable. If someone is asking informally to reduce change hours, should the employer say they must submit to flexible working? It depends how you want to do it. If you want to do it on an informal basis, not governed by the statutory provisions, then that's fine. Informal requests can be made. Just make sure that it's all recorded. Again, with an informal request, you don't fall within the statutory provisions, do you? So therefore, there is no statutory claim. But it depends whether you feel that it would be best suited for your organisation to have it formal. It is your decision, again, much like the flexible, the home working and hybrid. Right. Someone's coming up to normal, I think this is the last one, so I will go through this one. If someone is coming up to normal retirement age and they want to reduce their hours, we would look at this request via flexible working, but should we look to renew and review this agreement on an annual basis? You can put timescale on it. As we say, if we go right back to the initial slides, you can put that timescale on. And yes, forget about the normal retirement age. You might want to review an agreement on an annual basis anyway, mightn't you? So, yeah, I would suggest that ignore the normal retirement. Don't discriminate. So don't say that because you're coming up to retirement, yours is getting reviewed in 12 months, whereas Joe Bloggs, who's a 50-30, isn't. Yeah, so just ignore that bit and review it. Is that okay, everyone? It's really weird having nobody talking to you. Yeah, well, I will make sure these are sent out to everyone. And thank you very much for your time this morning. Thank you.